quite interesting. For the next topic, it's my privilege again to introduce Mr. Navi, Chairman of FDPPI. And we all heard him already in the first session. As I said in the earlier, when I introduced FDPPI, he's one of the thought leader and author of many books, and worked on, innovative concepts such as the data protection compliance management system. Be with me, whatever we are talking about in all our sessions, and tomorrow and day after tomorrow, you will really appreciate the terminology, what I'm trying to introduce in your minds, the data protection compliance management system, where he has authored it from FDPPI, and we are going to talk about it. Data Valuation Standards of India, a new initiative as such, how to value the data. Online Data Trust Score for self-evaluation tool for SMEs and MSMEs. Tirelessly, he himself had innovated, evolved it, and etc. Interestingly, he is also the qualified independent director certified by IICA, and he is also working currently on, again, totally a kind of new topic for the industry per se, like neuro rights legislation, which I already talked about. Only one country across the globe is talking about it, the Chile, if I'm right. And he's also working currently on it with a few stakeholders. And it's my privilege again to request him to come and deliver the keynote address on the topic, shape of things to come. I'm sure we all will be benefiting out of this session. And Navi sir, floor is yours. Thank you very much.
Thank you. I'll just share my screen and then start. Okay.
There you are. Thank you very much, sir. Please go ahead.
Oh, sorry. So since morning we were discussing various things, and we started with the concept called shape of things to come, because when we started planning for this particular event, we were in a situation where the government had withdrawn its PDPB 2019, and there was some uncertainty as to what would happen, in the sense that when will the new bill come. Fortunately, afterwards, I think the government did move a little fast. They came up with the telecom bill quickly, and they have now stated that they are likely to bring the new draft as early as possible. Morning, Mr. Rakesh Maheshwari was talking of about a month, because we are expecting that this bill should be getting into the mode of passing through the parliament in the February session. And if that has to happen, there has to be at least 2 months of time before that. So we are expecting that the draft would be out soon. In fact, I was expecting that it could come even before we start our program, but it has not happened. It is fine. So we were discussing that a professional organization like ours should be able to contribute to the government in giving our ideas on what should be the content of this new legislation. So that is why we looked at the shape of things to come as the theme, and we started working on that. I am going to present some ideas during this presentation. And later on, of course, we will be expanding this into greater a document. Now, I look at this withdrawal of PDPB 2019 as actually a new opportunity. Why is it a new opportunity? It is because we can now bring in a version which is appropriate for the needs of the country. The government has been talking about bringing a legislation which is in tune with the emerging technologies. So technology is the only kind of point which many people are looking at. But I am thinking that there are possibilities of making changes in several other aspects in terms of governance of personal data protection, and revamp the entire structure itself. So we feel that this is an opportunity where, without being constrained by the current thought process, and the current thought process is that there is a GDPR, it is a golden standard, and there is a CCPA, which is another golden standard for, let's say, consumer protection. Then everybody expects that India will have a clone of GDPR or a clone of a Singapore law, which, to start with, is a wrong concept according to me. We need to have a zero-based approach. And if we understand privacy, and if we know how privacy can be protected, then there is no need for us to actually copy articles from GDPR and then say this is Indian GDPR. In fact, UK did that once and created a UK GDPR. Subsequently, they realized that there is a need for change. But that was the time when people were very much concerned with Brexit, and there was people who were thinking guilty of having come out of the European Union, and they wanted to at least adopt the GDPR into their law to show their loyalty to the European Union. So I think India is not under that constraint, and in fact, India is actually frequently talking about standing on its own legs, whether it is any international say approach to foreign policy or legislation. So I think this is now an opportunity for us to have the new data protection law, which may have to take the best principles from everywhere, but need not necessarily be a copy of some other legislation. Now, where we stand today, many people have explained this. Rakesh Maheshwari spoke about it. Nandamohan also spoke about it. We have Information Technology Act 2000 amended in 2008 with the introduction of Section 43 capital A, and subsequently Reasonable Security Practice Rules, which was released on 11th April 2001. That is the operative law for data protection in India. This defines sensitive personal information, defines or adopts contract-based processing of personal data. It adopts purpose-based collection, informed consent, minimal collection, minimal retention, periodical updation for quality, security, cross-border restrictions. All that is there in Section 43A in the Reasonable Security Rules. In addition, it also recognizes right to access of the data subject, right to withdraw consent, about disclosure. All this is there. So therefore, what we have in 43 capital A is a mini version of the PDPB 2019. And the only difference was perhaps the regulatory authority was not there. Penalties were also different. And in India, ITA 2000 has been structured with a concept called due diligence, which comes under Section 79 as well as referred to under Section 85. This concept of due diligence is a very interesting concept in law. It says that a person should not limit himself to what is written down in a specific statute. He has to look outside and see what is good. In the sense, what is due diligence? Due diligence is something which a prudent person under similar circumstances would do. And he will be able to look out and see other laws, including a law like GDPR. If something is relevant to our context, he can use it. So that is the concept of due diligence. That is why in at least 3 or 4 high court decisions in recent days, the courts have made references to PDPB 2019 bill and talked about right to forget, which otherwise has no place in India. It has spoken about GDPR and given out judgments. The reason is that the compliance requirements according to the Indian law under ITA 2008 should be seen not only by what is stated in words in Information Technology Act, but by the concept of due diligence, which is the best practices which can be justified in the given context. Now, the context as of now is that the government had a legislative intention in bringing the Personal Data Protection Bill 2019, which itself was a revision of 2018, and the JPC1 went through it for 2 years. So what was there finally when JPC2 also added certain things? Now, this version of PDPB 2019, which was withdrawn, was a legislative intent at one particular point of time. No doubt it may be revised, but until it is revised, this remains the legislative intent. And because it is legislative intent, it is the due diligence under Information Technology Act, Section 43, capital A. And therefore, this Indian Data Protection Regulation will continue to be read under ITA 2000 and extended to the withdrawn PDPB 2019. I actually call this as something like what we call as Kadamba Bahu. Kadamba was a character in Ramayana who had hands which could reach anywhere. Likewise, the due diligence under Information Technology Act can reach to the entire withdrawn PDPB 2019 as well as to GDPR and so on, depending upon the context. So that is where we are standing today. Now, what is likely to happen immediately? Now, PDPB 2019 focused on what was called information privacy. So it focused on personal data protection and personal data governance through compliances such as privacy by design. This is how most of the data protection laws are constructed. Now, JPC2 actually added certain parts of non-personal data governance in the form of data breach reporting into this personal data protection law. And therefore, in the last days of PDPB 2019, we had to refer it as Data Protection Act 2021 or something of that nature, because certain aspects were of non-personal data were added into this personal data protection. One was the notification of the data breach to the TPA created under PDPB. Second was that anonymized data. There was a kind of reference that anonymized personal data is not absolute non-personal data earlier, and even today, anonymized personal data, to my mind, is non-personal data. There is no need to consider it as another form of personal data, because anonymization by definition means breaking all identity aspects in such a manner that it cannot be re-identified. Anything less than that is only pseudonymization or de-identification. So real anonymization, if you want to use the term anonymization, it has to be an irreversible process. Now, whenever we say irreversible, there is a technology dependence. Certain technologies are not perfect. Therefore, what is considered as irreversible today may not be so tomorrow, or may not be so because there is a very intelligent criminal who breaks your code. But this is something which the technology industry has to face continuously, and whether it is encryption or any other factor, there is nothing called 100% protection. A criminal can break through. But if somebody breaks through what is considered as a reasonable security or process, that amounts to criminality, and it is not something which should be considered as a compliance requirement. You cannot say that you should build an anonymization process which will never be broken even by quantum computing and so on. It is not possible. So what the law should state is have a standard for anonymization and say anything above that standard is when it is used, the anonymized personal data becomes non-personal data. Anything below the threshold may be considered as negligent anonymization, and the person who claims it to be anonymized can be suitably disciplined. So that is how the distinction has to be made. But this JPC2 somehow thought that we should have this anonymized personal data as if it's an extension of personal data, and added a few things there. Now, there is otherwise non-personal data has been something which ITA 2000 has addressed, and with 43 capital A, ITA 2000 addressed both personal data and non-personal data from the perspective of security, because whatever is not secure becomes a cyber crime kind of a candidate. And as far as the governance is concerned, ITA 2000 spoke something about security, something about digital signature and so on. So there were some aspects of governance. And this 43 capital A rules, reasonable security practices, and section 79 rules, and now the digital media intermediary rules, they are all governance aspects which state that an organization should govern its personal data of a particular nature like this. So ITA 2000 handles both personal and non-personal data governance as well as the protection in one single law. Out of it, now we are taking out the personal data into a secondary law called Personal Data Protection Law. So now when the government comes up with a new legislation, we do not know whether they will continue to have this as a combined law like what statements they have made, or they will go back to the concept under which PDPB 2018 was created, where and even early version of PDP 2019, where only personal data protection is handled by this law, and non-personal data protection will be handled by the earlier ITA 2000, which also may be somewhat revised. So we have to look at personal data protection, personal data governance, non-personal data protection, and non-personal data governance. And that is what Chris Gopalakrishna committee also suggested. Non-personal data governance requires to be handled in a particular manner, and it should be possible to introduce a data exchange in which monetization can take place. Now, those things can be brought into this new legislation. In fact, there is a move that Information Technology Act also is likely to be amended. If so, there is an opportunity to bring this non-personal data aspect separately under ITA 2000, and we can leave personal data concepts under the ITA, under the new data protection law. There is one small overlapping part, which is about cyber criminality, and worldwide the data protection laws have remained laws where the compensations and other things are of civil nature, and criminal punishments are normally meted out through other laws like Computer Abuse Act or something like that. So maybe we may have a similar thing where the crimes may still continue to be handled in ITA 2000, because any kind of violation of law resulting in a harm to any individual has to be considered as a crime, and therefore ITA 2000 is good enough to handle that. In fact, current 43 itself is sufficient, because any reduction in the value of information residing inside a computer is a crime under 43 combined with section 66. So it already addresses that requirement. So whether this distinction will be taken or not, we do not know. If it is to be combined, then of course, as Nanda Mohan Shenoy was telling, if you combine personal data, non-personal data, governance, as well as protection into one single comprehensive act, then perhaps we are getting into what he calls as the Kichdi law or something like that. We hope it will not happen like that. Even if it happens, what I have tried to propose is, let us create chapterization in this new law so that we can segregate the laws related to personal data governance at one place, laws related to personal data protection at one place, laws related to non-personal data protection at one place, and non-personal data governance in another place. So at least 4 different divisions, part A, B, C, D of this act, which will work as if it is 4 different acts. Something like that is what is recommended. Now, my thought process is that we should use this opportunity to come up with a new law to actually leapfrog into the next gen law, not looking only at the GDPR and CCPA, but develop a made in India law, a zero-based approach. And that is where we can make the best use of this opportunity. India has done this in the telecom area many times, that we have leapfrogged one particular stage and gone into the next stage. That is why we are ahead of many other countries today. We are also in the finance world, we are ahead of the advanced countries. Our UPI system is far, far ahead of what is there in USA or something like that. So therefore, similarly, in data protection law also, we can get directly into the next gen law. So keeping that in mind, I am going to briefly touch about a few of what I call as a wish list, because this is a wish list in the sense that we do not know government will actually accept some of these things, or they will fall back into the proven area of just make a copy of Article 24 of GDPR becomes Section 24 of PDPB, then it is very easy for everybody to say that this is as good as GDPR and don't criticize. So despite that, people will criticize. That is what has happened. Our cross-border data restrictions were actually less than what GDPR had put on their listing, but still people said that GDPR is better and we are not, our law is very restrictive. That will continue because people are not rational when they actually criticize. So we will look at it as a wish list, just conceptually placing something for this professional audience so that this discussion can go forward. Now, what I will try to concentrate is one, defining privacy and the scope of what we call as the protection under this act, then rights-based construction of the law, innovations such as neuro rights, privacy compliant data monetization, then data residency or cross-border restrictions in a proper manner suitable for India, then technology accommodation and AI regulation, compliance code with sectoral flexibility. These are the things which I'm going to very briefly talk in the next 45 minutes or so. Now, so far, if you ask anybody in India, where is privacy protected? Everybody says it is a fundamental right. Now, under the constitution, but when did it come? It came only recently when the Puttaswamy judgment came. Until that time, MP Sharma judgment was there since 1954, which said this is a right, no doubt, but it is not a fundamental right. And subsequently, in many judgments like this Karak Singh and Rajgopalan case and other things, we had the Supreme Court interpretations of what is a privacy right, which was basically a physical privacy kind of a concept. So we have been working on what the Supreme Court had at different points of time interpreted as what is privacy right, and it was a completely open-ended interpretation. And we know that Supreme Court as well as other courts have always been used to interpreting and reinterpreting, and there is no consistency in many of these decisions. So what is privacy today, according to one bench, tomorrow it may be overturned. Now, when we come to the industry and we are the persons who are expected to be compliant, then we want a little more clarity, and we don't want to run to Supreme Court every time and ask them, is this privacy right? Is this privacy right? And so on. So there is a need to bring privacy protection into statutory law. Right now, what is happening is, even if you take Puttaswamy judgment, which everybody quotes as this is where the court has said that this is a fundamental right. It is only what we call as arbiter dictum. It is not the final order of the court. Before giving the final order, the judges discussed so many issues, and during that process, they have commented on what should be the privacy right and put it down in that particular judgment, out of which also some differences could be there. The final order was considered unanimous, but that was only with respect to 2-3 things, whether from MP Sharma has to be overruled or something like that. So rest of the things about what is privacy is what we call as arbiter dictum and is not specified in the law. And today we are all in the corporate sector are asked to take that arbiter dictum or the statements made out of a court order, but as the intention of the judge at that particular point of time as the law of the land. This leads to needless controversies in the compliance environment, and I feel it is preferable if we make a positive statutory statement in this new Data Protection Act that privacy right is something which is protected under this law. This law should be the law which has a clause like that. Earlier, PDPB did not have that. We directly went into the kind of information privacy issues. It was more like a procedural law rather than a main law with a proper definition of privacy. I think now we need to do that because there is an opportunity now. So a proper definition of privacy, which may include privacy outside information privacy. See, right now we are talking of data protection law only because one of the judges in the Puttaswamy judgment used the word information privacy and said information privacy means that the personal information about an individual, if it is in electronic form, he should have the right of choice to tell the data processor how he should collect it, how he should process it. Now, beyond this information privacy, there could be privacy in terms of oral communication, in terms of written communication. The information related laws like Data Protection Act cannot easily handle that, except that we try to compromise, saying that Information Technology Act is there, Section 4 is there, which says that wherever any law requires a document to be in writing, if it is rendered in an electronic form, then this law will be applicable. So if you have a law for electronic documents, you can apply it in some way to laws of paper documents, because today every paper document is also a computer generated document, so it is easy to extend. But if it is possible, it is better we make a statement that privacy is also recognized as a right which cannot be infringed orally or through written documents, and it need not necessarily be restricted to the digital context. So this is something which is possible now. Now, my thought is that it should be the responsibility of the government to interpret what Supreme Court says. And for a company, if I am the CEO, I should not be asked to interpret what the Supreme Court says. I am prepared to make an interpretation of what the law says. Let the government reduce the uncertainty of the judicial interpretation by creating a law. I will use my legal counsels and my expertise in trying to interpret the statutory law and convert it into the process by which I do the compliance. This is why I hold compliance by default as something which we should work on. This concept of privacy by default, as if a IT company which is profit oriented will be able to protect the privacy, which is a human right of an individual, that is completely a non-starter. It is like expecting the companies to perhaps remove poverty in India. Poverty in India has to be removed by the government. Government can give some incentives and say, this is a corporate social program, you do it. Company will do the corporate social program. That is where the uncertainty of a law as an interpretation to be done of the judicial verdict should be reduced into more exact prescriptions. So that is where we say that the principle behind the new law should be compliance by default should be the obligation, for which government should say what should be the compliance. Now, keeping that in view, we may have to define privacy. Now, how to define privacy? I don't know. That it is a very complicated thing which constitutional law experts will have to do. But I feel that an attempt can be made approximately in these kind of lines. Okay, just carefully read what can be done. One is privacy is part of the right to life and liberty of an individual as provided under Article 21 of the Constitution of India, subject to due process as laid down in this Act. When I say this, we are converting the Supreme Court judgment into actual words of this particular section, and then saying that in practical terms, the due process is actually laid down in this Act. So rest of the people who want to actually comply with it, look at this as a due process. Don't worry about the interpretation of what is life, what is liberty, what is right to life, whether, as some judge said, what you eat, what you, where you go, these are all parts of privacy. That is what some judges say. You can expand it like that to anything and everything, but a company cannot implement compliance programs for something which the 9-member Supreme Court bench could not take the responsibility of giving a definition. If they cannot give a definition, how do you expect a CEO who is an engineering graduate, a computer science graduate, or somebody can perhaps interpret? It is too much to expect. The second clause of this definition, of course, it is better to have this, privacy right referred to in the section above is subject to reasonable restrictions. This is part of the Supreme Court judgment, but I feel it is better to put it here. Otherwise, this itself will become a subject matter of a litigation in Supreme Court of India. Then the third part of this definition is to distinguish different types of privacy. So I feel that privacy as defined above, we should say includes physical privacy, which is something about the choice of how you share the physical space, mental privacy, neuro-privacy, and information privacy. Now, the word mental privacy is sometimes used as neuro-privacy, but I feel that we can keep a distinction because the kind of privacy which we are trying to address now, which is the state of mind, is actually the mental privacy which we are already addressing. So when we say privacy today, we are not talking about physical privacy, like a person who is going in the Mumbai, let's say local, he is not worried about the persons who are jostling around him. He still feels he is free and he doesn't feel that his privacy has been threatened. At the same time, you put a person in, say, solitary confinement in a jail, he is alone, nobody is near him, but he will not feel that he is enjoying the privacy right. So the privacy right is actually a state of mind. A person can feel private or whatever you interpret out of that, even when he is amongst the crowd, and at the same time, he may not feel so even if he is isolated. Therefore, mental privacy is what we are addressing today as a state of mind. So physical privacy and mental privacy, you can say, are things which we are already addressing. Neuro-privacy is something to do with the determination of to what extent an individual can choose to share his neurospace. Say, mental space and neurospace are different. Neurospace means you are directly interfering with the functioning of the brain. The mental privacy is the outward manifestation of the neurons in terms of thoughts and other things. Today, many of our profiling requirements and other things, we say that you are changing the opinion of a data subject unfairly. Therefore, that is part of the current privacy law. But changing the outward, thought process is like a person who is wearing a glass. He changes what he looks at. I wear a colored glass, I may look at colors differently. Likewise, changing the thought is something which is an outer manifestation of the mind, and we are addressing that to some extent in the current law, saying that it should not be done unfairly. It amounts to deceiving the person. That is, you try to make a person take a decision which he does not want to take, like in dark patterns and other things. That is unfair, and the current privacy laws do address it. And even the PDPB did address that by saying that psychological manipulation is considered as a harm under the proposed PDPB. So neuroprivacy is something beyond that, which directly tackles the neurotic waves which are coming out from the human brain, which we consider as electromagnetic waves. And the electromagnetic waves come out of the human body. And if you have the right kind of equipment, you can capture it. Then if you have got right type of equipment, you can also input externally a neuro data into the human brain. That is what needs to be protected in the neuro privacy. Now, the other concept is information privacy. I feel that we should not keep this confusion going. That Data Protection Act, as we know, whether it is GDPR or CCPA or most of it, it is nothing but information privacy, because it starts with saying collection of data is to be done in this particular manner. And most of the time it is data which is in electronic form, though there is an artificial extension to saying file systems or something like that. So I would rather like to say that we will protect information privacy, because whatever we say in terms of compliance and other things in the 98 articles of, say, GDPR is towards information data in information form. One section somewhere we mentioned that it is also applicable to filing systems will not make it easy for a compliance person, because every time what is required for information and what is required for physical documents may be different. So information privacy is a category of privacy, which is what the D.N. Chandrachud and others mentioned in the privacy document. Now, while defining this, if you have seen, I have used the terminology of sharing. That is, individual may choose to share. So the choice of how to share is what is important. And so sharing itself needs to be defined. I have tried to present here one thought, which again is a very controversial thought. I am not afraid of making controversial statements, so you may disagree with me, but I am saying sharing in this context means making the information available to another human being in such form that it can be experienced by that receiver through any of the physical senses of seeing, hearing, touching, smelling, or tasting, in such a manner that the identity will be revealed, which means only when the identity can be experienced by another human being through the sensory organs, we say that there has been a disclosure. There are many other instances where a human person does not receive the information. Maybe it may come into a machine. And if the machine does not release it to a human person, then the identity is killed within the machine. In that case, we say it has not been disclosed. It has not been privacy. Personal information has not been accessed. In fact, even if you take a software which does anonymization of personal data, you have an algorithm. The algorithm receives identified data. It gives an output of unidentifiable data. So the machine or the software has a view of the identity, but the algorithm works in such a manner that even the admin of the particular algorithm does not get access to identity. Therefore, we believe that it is an anonymization algorithm, and what comes in is identifiable, what goes out is not identifiable. So the machine has a kind of a privileged status. And I feel we should recognize this, and the privacy has to be redefined by recognizing that there could be devices which actually handle identified personal data in such a manner that no human person will be able to see the identity. It dies within the machine system. In that case, it should be possible to consider that that is not a disclosure of a personal data. This is a concept. Okay. Then the other one is the terminology called data privacy. We many times use it, and most of the industry people actually think data privacy and data subjects privacy are one and the same, because in human rights and this Personal Data Protection Act, following what the Supreme Court wants as protection of the state of mind, etc., that is actually the protection of the privacy of the data subject. It is not the protection of the data. Protection of data is what information security people have been doing for a long time. Confidentiality, integrity, and availability may be extended to authentication and non-repudiation. Now, I feel that we should stop confusing people with data privacy and data subjects privacy. Or, as we were discussing in the previous session, we should have a data protection officer and a chief privacy officer. Say privacy protection and data protection. Why should we? If it is different, let us make it as different. So data privacy or privacy of data in this context of law means preservation of confidentiality, integrity, etc. If you add that as an explanation, the privacy definition will look much more understandable than what it is today. The second point which I would like the Act to consider is, we can consider whether we can declare something as a protected right of a protected person, because they will protect and the protected data. This protected data is a concept which has been used in HIPAA also. Okay. Now, protected right under this Act means the right to privacy, which is defined in a particular way, and it shall be the right that is protected through the due process set by this Act. So that is clear. That is the protected right. Now the question is, whose protected right is protected by this law? So that requires definition of who is the protected person. I feel that we can say that only living natural persons should be the protected persons. And then Persons who are recognized citizen of India and residing in India, they are the persons to whom our constitution is basically obligated to. Now, living natural persons who is a recognized citizen of a sovereign country, some other country, recognized by India, and he is under authorized residence in the territory of India, we can extend this protection. So protected, he can also be included as a protected person. What I want to exclude is that this protection under this act should not be available to natural persons who are under unauthorized residence in India. The information, and of course, information related to juridical persons is also to be excluded, and the information of a deceased individual. Of course, this is also a very controversial suggestion because I am including the provisions of CAA into this. Okay, but I feel that we don't have an obligation to protect the rights. Okay, human rights people may say that all humans are equal, even animals have got rights, but maybe it's a restricted right. So we may have to have a distinction between restricted right and the protected right. Today, most of the Supreme Court litigation happens because the right of a terrorist of a different country is sought to be protected. Now we are wasting our national resources on that. So I feel that we should make a distinction. Rights enjoyed by a citizen of India are something, rights for others can be different. Okay, as you may agree, disagree, but this is my point of view. Protected data under this act, again, we can say whether it is oral, written, or electronic form. You can define it in such a manner that wrongful collection or processing or disclosure of some data which causes harm to the protected person may be called as protected data. Now, next, who exercises the right on personal data? This comes to the ownership. Now, right under this act over protected data shall belong to the person to whom the data relates to. Now, legally, it is difficult to define whether data is a property or not. It is like a property. It is like licensing of an intellectual property right or something like that. So 100% whether it is a tangible or intangible property is a difficult thing to say. But still, you can assign the rights to a person to whom it relates to. Now, if the protected data relates to more than one individual, where it is possible, for example, a telephone conversation creates a conversation as the data. Now, does it belong to A or B when A and B are conversing? Actually, it is generated simultaneously by both, and we have to recognize the joint data ownership or right in such cases. And there are instances where data is passed on from one person to another person sequentially, and each subsequent person adds some value to the data. Now, today we are saying that if a data subject gives me a data, I create a profile out of it. The profile is personal data attached to the original data. And if the person wants data portability, I am supposed to give this profile also to him, unless I can defend it under trade secret or from some other kind of a thing. There may be a few laws which may make a distinction as far as the right to access or right to portability is concerned, by saying that you have to return only data supplied by the data principle. But most of the other laws consider that the data built on the personal data belongs to the data subject. I feel that the value created by the person who builds that data should belong to him. It is open to him to share that value with the data subject, and that should be part of the consent. When I ask you to give your personal data, I may say that I am going to make 10 rupees profit out of it, after which I will give you 1 rupee, 9 rupees I will keep, and I ask you to give me a consent for that. And that consent, if it is given in an informed and manner by an adult, I think should be even acceptable. So who exercises the right should be determined by law, and the additive value hypothesis of data should also be brought into the law. Now, the next question is, now most of the data protection laws have got two major chapters, which is the legal basis for processing, which we call as principles of processing, and then there are rights. And then, of course, there is compliance requirements, three different elements. So I feel a better approach could be of defining even the principles of processing as a guaranteed right of the data principle. For example, the issues like this purpose limitation, collection limitation, etc., they may all be called as subordinated rights. And the protection of right to privacy, we may define as include subordinated rights prescribed under the Act. By this, what happens is that the data subject will have an ability to have compensation and other things as a part of his right. Because if the company is negligent in processing his personal data, because purpose limitation or collection limitation or something, the retention limitation has not been followed, then the data subject gets a right to question it. Today, only the Data Protection Authority can question it. The data subject can only question if there is a harm done to him. To prove that a harm has been committed to me and it is worth 10,000 rupees, that is for the Supreme Court to decide. So, in practical terms, it is very difficult for data subjects to actually get benefit out of improper use of data by organizations. So I feel that defining the data principles as part of a right would help in this aspect. Next, currently all laws are based on the right of choice. Now, there is a practical situation where minors, we feel that they don't have the ability to take a choice. Therefore, we say that some guardian should be there, and the guardian should be a parent, natural guardian, or it may be a court-appointed guardian. Somehow, the law has found a way to exercise the right of choice for a minor through a third party, who may be a parent. So that concept is there. Now we need to extend that concept to other critical things like neuro rights. Now, I have been discussing with many medical professionals about what kind of consents they obtain in the case of surgeries or medical things. Okay, in the case of an ordinary surgery or something like that, the patient is in good mental condition to take a decision, he gives the decision. But still it is under some kind of a coercion or a situation where he is afraid that if he does not agree to what the doctor says, then the consequences would be difficult. So most of the time, when the doctor asks for a consent for, say, operation, I don't think it is an informed decision of the patient which leads him to say, yes, you go ahead, even though the possibility of anesthesia killing me is 10%. You say even a dental kind of an operation has sometimes killed people. So there is a risk. There is a risk of loss, and doctors may sometimes say it, and the patient just accepts it. Now, when we come to, say, neurosurgery, now, neurosurgery is actually done for people who have got some kind of a deficiency in the neurological structure, and which itself should be a suspicion that he may not be in a position to take the particular choice. It is like your truth serum kind of a thing situation. That is, the person is not in a position to take a rational decision. Now, how do we take consent in such situations? So I feel that we should actually think of a different level of consent. Today, we have got the ordinary consent, which we take for everything, deemed consent and other things. Then we have got a special consents, which we take when we have, say, sensitive personal data. But beyond that, there is nothing. Okay, and this special consent is basically a kind of consent where there is better clarity. Now, in the case of neurosurgery or something like that, the type of consent should be witnessed consent. So we have to define something called witnessed consent, which means that there has to be other people who understand and explain it to the person and takes responsibility that this decision has been taken consciously. So the system of data protection and the consents should include something called a witnessed consent. There is also another concept of consent which I would like to be considered, I'll come to it perhaps later, which is called discovery consent. Because many times big data and others, they don't know what they are going to do with the data, but they would like to have the consent, and they may find out the purpose on a later day. Now, how do we take that? Say in the case of, let us say, exploration of, say, mining rights and other things, these things do happen. I want mining rights. Now, the person doesn't know whether there is gold below that or there's a mineral below the earth. But consent is taken with a condition that if it happens to become gold, this is how I will reward you. If this happens, oil, this is how I reward you. Similarly, a discovery consent or an exploratory consent is another form of consent we should think of. Okay, now coming to the entities, today we have got the data subject, data principal, or the data principal, data controller, and data processor. Basically, I feel that we need to look at two other subcategories of these entities. One is the data collection agent, another is the data storage agent. I feel that in the industry, there are people who, let us say, do only storage of data, maybe even encrypted data. Now, today, storing of data is also processing, and collection of data is also processing. The collection is done on behalf of somebody else who determines the purpose. So I feel that we should have some kind of a differentiation in the compliance obligations by introducing these different categories, just like the joint data principles. In fact, the term data fiduciary was as an innovation which Justice Sri Krishna introduced. And of course, it is better than data controller. But I have a feeling that in the upcoming new law, we should look at calling this person who actually determines the purpose and means, etc., as a data manager. The reason why I suggest this is this data fiduciary is a very onerous responsibility, because a fiduciary is expected to work in trust. And even if the data principal doesn't know what is good for him, the data fiduciary should know what is good for him and then take a decision. This, I think, in the industrial context is a very onerous development. I think we should not hoist this responsibility on the industry. In fact, this data fiduciary, data processor, consent manager, and all these people belong to what I call as the category of data guardians. Out of it, somebody only manages, somebody only processes, and so on. Now, a couple of things which we also should look at is monetization. Now, monetization is considered something like a disgusting thought and anathema, and we should prescribe it. And that is how the IRCTC issue was handled by the people. But I feel that data monetization is not to be treated as the outcast of data processing. Because if you say data monetization is related to advertising, advertising is an essential aspect of business. Without advertising, you do not know what product is there to buy and what services are there, and the buyer does have a proper information. So advertising has got a logic. If advertising has got a logic, profiling for advertising has got a logic. And converting that profile into money is a natural process of business. So data monetization should be treated with, not with hate or something like that. You can regulate it. So monetization of data has to be defined in this law as a structured plan to generate revenue. You can still ensure that it is privacy compliant. So I feel privacy compliant monetization is feasible and it should be permitted. One way by which data monetization can be done with privacy consent is using of a pseudonymized data or anonymized data. Why don't we make it mandatory when it has to be monetized? Monetization of a pseudonymized data reduces the risk of privacy harm to the identified person. So we can define some standards of pseudonymization, like standards of anonymization, introduce monetization. If you introduce monetization, it is transparency. Today, every company makes money out of data, but the law says that you cannot do it without a consent. Now, when consent is taken, nobody says I'm going to make money out of it. But when Zomato comes with a public issue, everybody invests in that because they think they have got so much of data, they can do so many things in future. Data has been valued in the minds of people and it is monetized and payment is made in an IPO. But when it comes to lawmaking, we say, no, without consent, you cannot monetize it. It's impractical. And we need to change this approach. We have to be transparent. Law has to be transparent, allow data monetization and put whatever restrictions are there for that purpose. So this also has got relation to data valuation. We talk of data breach management, but we never make it mandatory for an organization to tell its investors and to the Data Protection Authority what is the value of data it is managing. Without declaring the value of data, you allow companies to actually do business, and that is why we get surprised when a ransomware person asks for 10 crores from a company. That company will say, I never knew that I had got 10 crores worth of data. Similarly, there are instances where mergers and acquisitions happen where the value of the data is actually not brought to the books at all, and it leads to cheating of the shareholders of the company. We have in India at least 2 cases. One was the civil shareholders actually lost the value of running to I think 6-7 lakh crores of rupees worth the data, which was simply transferred to a company called TransUnion. Nobody objected to that because nobody had visibility. Similarly, this Net4 India was declared insolvent, though it had got assets much beyond its liabilities. So I feel that at the time of registration of a significant data fiduciary, and in many other instances, we must make it mandatory to an organization to declare at least the approximate value of the data it handles. That will determine how much of control the Data Protection Authority has to give, not necessarily only on the basis of the volume of data. 50,000 or 5 million data sets is currently the threshold for significant data fiduciaries. But it may be a worthless data which is available everywhere, as against somebody who is having only 10,000 data, it is all DNA profiling. Now that should be considered significant data fiduciary because the value and criticality of the data is better. So that way, privacy by design policy and registration of data fiduciaries should make it mandatory for data valuation to be disclosed, is a question. Now, this technical view of information, to some extent, I already told you that technology can actually take a personally identified data and release identifiable, anonymized, or pseudonymized information. And only when it is identifiable output, then there is a privacy related issue. Otherwise, don't treat it as a disclosure at all. So that has to be brought into the law. Okay. Now, when it comes to artificial intelligence, we must remember that India has got a law in ITA 2000, which actually makes the owner of an algorithm responsible for the acts of the algorithm. So we have got ITA 2000, which has a control on misuse of AI. Probably that's why I think in the earlier version, the JPC 2 version, there was something called an assurance certification for algorithms, which is like a bias audit. And hopefully that will continue. And that is a regulation of the AI. I don't know whether we require a separate law for AI regulation. From the privacy perspective, if you want it for other things like in telemedicine, you may require a law for telemedicine, but for telemedicine privacy, perhaps you can do it within the current law. Like that, we can think whether some parts of AI regulation can be brought into this new law. As far as cross-border restrictions are concerned, I have the opinion that the clauses which the EU is trying to impose on data importers is very onerous, is not acceptable by any sovereign country. So we need to actually build some kind of a protection for the Indian companies who simply go and sign contracts without understanding what is there in the contract, because they want business, they will sign on anything. If you say you give a signature and say you'll commit suicide, that also people will sign. And undue influence is being used by data exporters from EU to get unconscionable contracts being signed in the form of SCC, and that needs to be protected by making the Data Protection Authority a default super owner of all data which is in India. So in certain cases, this Data Protection Authority's permission should be required. Just as you say, before you take legal action against a government official, you need the permission of somebody higher than that. Likewise, you need to create a protection for the personal data coming from outside, and then only the contractual agreements will be actually legally acceptable in India. Otherwise, they want us to sign a contract saying that I will not allow the intelligence agency to look at this particular law. I will not allow the police to look at this law. How is it possible for an Indian company to say that they will not let the law enforcement authority or the court to take a view on the data, even if that data belongs to a EU person? If there is a legal process for that, that may be a say terrorist activity and other things, law enforcement has to do that. Now, currently, cross-border restrictions are not practical, and we need to actually have something of protection built on that. Deceased persons' rights have to be protected outside the privacy law, because privacy is not something which a deceased person can claim as a right. And even if you take the consent or the contract as the basis of processing, once a person dies, then obviously this consent does not have a value. Therefore, deceased persons need to be kept out of it. This was something which was not done in PDPB 2019. Actually, JPC2 added something for deceased persons which was legally not fully tenable. Otherwise, the consent is will remain or should remain as the lawful basis of processing, because that is the basis of privacy. And as I told you, we can introduce witnessed consent and consent for profiling as probably acceptable. Now, one last point about the obligations of the government. Now, this is a much discussed point. There is a simplification which can be done by actually ensuring that an obligation is put on the government, saying all government bodies shall have the duty to protect the right of the privacy as per this constitution, and they will institute some reasonable and proportionate measures, and they will designate a senior officer and something like this, and leave the detailing of whether there should be a privacy by default policy to be filed with a data protection authority, where the DPIA has to be filed with the data protection authority. These are all things which are not going to work when one government secretary has to provide the information to the data protection authority, who may be another secretary until last day. Now he has been promoted as the chairman of the data protection authority. So it is impractical in some instances to say that the GDPR kind of regulations should be made applicable to government departments. So the one way is to simplify it in some manner, though many people will say then we are diluting the whole purpose of the privacy. Then another thing is, if you look at GDPR, GDPR is a law which says that there is a separate rule for churches and religious associations. So in a way, it is a non-secular legislation. So in India, PDPP does not make any distinction for non-commercial, charitable, and religious organizations. So what is good for, say, Infosys or a Wipro, the same law is applicable to a temple or something which also handles personal data. In fact, if you take TTD, then it will have the largest amount of personal data, including the biometric data, the Aadhaar data, and other things. And they will not be able to find a data protection officer who can protect that. So there is a need to distinguish, just as we make a distinction between a small entity and the large entity, we may have to make a distinction of non-commercial, charitable, and religious organization, and don't brush it with the same paint as for the commercial organizations and also for the government. So there will be three different levels. Commercial organizations, one set of compliance regulations, government, another set of compliance regulations, and some exempted category like this religious and charitable is necessary. Otherwise, we will not be able to have a acceptable law. So I think I will close this discussion here because we have called out another 30 minutes for the neuro rights presentation by Professor Rafael Yuste of Columbia. That will follow this. and thereafter we will be getting into the awards section. But if there is any urgent question which Mr. Ramesh or Samyogita.
Sir, only very quickly, there are only two questions if we can address it.
Yeah.
See, question by Vijaya. But does this data sharing result into some kind of issues in transfers?
Issues in transfer of, see, I've said that in the mergers and acquisitions, yes, it may. We have to address that. Okay.
Right.
What I am trying to distinguish is sharing to a human being and sharing to a processing, a computational process. I have said that when the identity actually is only shared with the computational process and what comes out of it is not identified, that should be allowed, is what I am saying.
Proposing.
At the same time, the admin of that algorithm also should not be able to access it. Okay, for which a suitable assurance can be there, and technology, we can do that. Like you have got today many devices which you try to open it, it will get destroyed. No, that kind of technology can be built in so that there can be certified assurance that a particular program does not release identified information. That should be acceptable, is what I am trying to suggest.
Excellent, excellent. Next question from Dr. S. Gomati, Shankara Gomati.
Yeah.
Non-repudiation in which data format may change. Okay, is there a question? Non-repudiation in which?
Non-repudiation essentially means that every data must have a owner.
Correct.
Accountability. Okay. And the ownership accountability should be of that level that the person should not be able to repudiate it later on in a court of law or somewhere else.
Right.
So it determines that there has to be accountability, and accountability should be acceptable to the judicial authority. It is like your digital signature.
Right.
Okay.
Last question, sir.
Yeah.
From her again, Dr. Gomati. Is the quantum computing breaks the encryption?
Yeah. Now today, the security people don't have an answer to this. No.
Right.
Every encryption, whether you have 1024-bit, may ultimately be broken. But it doesn't mean that if the law recognizes 1024-bit as an acceptable security, anybody who uses that encryption, if it is broken by using quantum computing or by using some other technology, that is an extra effort which a criminal put him in jail. I am saying that there is a standard. Anybody who tries to overcome that standard, that should be considered as a deliberate act to override the law and make that a criminal offense. But to the complaint company, don't say that you should create a security which will never be broken even by quantum computing, etc. It is not feasible. So give him a standard based on the current context, which can be revised from time to time, and say this is the standard. Anybody who does security up to the standard is considered compliant. Now, anybody who overrides this by extra efforts, you should ask a question to that criminal. Why did he do this? So if somebody says anonymization is not perfect, you can de-anonymize it. Then you can de-anonymize it because you are putting special efforts. I and you cannot de-anonymize it. If some anonymized information comes over email, we have to put some software and do something. Now, if I am doing that, it shows my malicious intention, and that should be made punishable. This is what I feel.
Excellent, excellent. Great, sir. Great. Because of the time constraint, I would like to, on behalf of everybody, one of the, no doubt about it, excellent session, and what a thought process. I really feel that at least when the government of India start thinking of applying that new law, they are considering, taking your thoughts definitely, and I'm sure that this message, this video should reach them. And interestingly, only one bullet I wanted to mention. I don't know, sir, as if there is a kind of discussion between you and Mr. Rakesh Maheshwari. Seriously, side of thought process, right? What he said shaped of things to come at the time of closing ceremony, and from where you have pitched in, you covered many new topics, but some of the topics he also talked about it. Quite interesting, and I wish, because he said one important bullet, if you remember, opportunity again from the Indian new law perspective that the lessons learned out of or pitfalls of the existing laws could be covered. Oh, beautiful. Today you are talking about data monetization, neuro privacy rights you are talking about. You are talking about data valuation. You are talking about data breach management, how to bring the technology. He talked about AI to machine language into the system. You are introducing new roles like beautifully data manager, data storage agent, data collection agent, the exploratory consent to mind boggling. Thank you very much, sir, really. And I'm sure this will go in a very big way. Your inputs would be, I'm hoping that they will take it forward. Thank you very much, Srini.